This online event is recorded and it will be available on HBA-UK's platforms. My name is Greg Hatzigrigoriadis, Head of Communications Committee of the Hellenic Bankers Association UK, and I will be coordinating today's discussion. This is an information session on the EU settlement scheme addressed to all EU citizens and their families in the UK. On behalf of HBA-UK, we would like to thank the delegation of the EU to the UK for assisting us in the organization of this online event, as well as the Embassy of Greece and the Cyprus High Commission for bringing this formal gathering under their auspices. Let's welcome and introduce our speakers for this evening. First of all, the Consul General of the High Commission of Cyprus, Mr. Theodoros Gotsis. Secondly, the Deputy Head of Mission of the Embassy of Greece, Mrs. Pinelopi Micha. And last but not least, the Director and Founding Solicitor of Seraphus and a Special Advisor to the Delegation of the EU to the UK, Mr. Christopher Desira, who has over 15 years of experience in the areas of law and immigration. After some initial remarks by the Embassy's representatives, we will proceed with the presentation prepared by Christopher Desira, which will be followed by a Q&A session and closing remark by the Chairman of the Hellenic Bankers Association UK, Mr. Louis Loizou. For any questions before we start, please send them in the Zoom chat and the speakers will try to address them after their initial remarks. Mr. Theodoros Gotsis, the floor is yours for your initial remarks. Thank you.
Thank you very much, Greg, and good afternoon to everybody. Thank you for the kind initiative to organize this important webinar in a very timely time juncture. I know from his work, Mr. Desira is always available to answer the many questions that arise for our citizens. Of course, the EU settlement scheme and the whole Brexit business was a huge challenge for us in the Cyprus High Commission, as well as in all other EU member states embassies in the UK, of course, for our Greek colleagues as well. Now we are coming to the end of this of the current stage of this process, with the deadline on the 30th of June for the submission of the application for the pre-settled or settled status from our citizens. We have come a long way after the Brexit referendum back in 2016. 5 years later, Brexit has happened in the beginning of this year. And we are coming to the point to see how our citizens are affected from its consequences. But the most important thing currently is for the remaining citizens, all EU citizens that didn't apply as yet for the EU settlement scheme to apply in the remaining 8 days. This is very important for all of us. And after that, of course, I'm sure that Christopher will explain what follows, what are the options. But in any case, currently we focus on taking advantage of the remaining time for all our citizens that haven't applied. So without further ado, we will hear the presentations and maybe we can discuss or have a Q&A later. And that's from me for now. Thank you.
Thank you, Theodor. Thank you, Mr. Theodoros Gotsis. Let's now move to Mrs. Pinelopi Micha, who has actually provided us with her recorded message. Michali, please go ahead with the message.
Yes. Just give me a second. Can you see her on the screen? Yes.
The voice is a little bit low, Michali.
Back to you, Greg.
Thank you so much. Thank you so much, Michali. Now I think the floor is for Mr. Christopher Desira to provide us with his useful presentation. Mr. Desira, you have the floor.
Thank you very much, and thanks for the lovely introduction and inviting me today. Please may I ask the host of tonight's event to allow me to screen share some presentation slides so I can share the slides that I have with you all tonight. And while that's happening, just a brief introduction. As you've heard, my name is Christopher Desira. I'm a solicitor and director of a law firm called Seraphus. We have been providing advice to the European Delegation and the European Commission since 2017 on Brexit and the EU settlement scheme. So we're uniquely placed to be able to give this presentation to you today and also to be able to answer any questions that you have with us. So hopefully we'll be able to share my slides shortly. I have put together a presentation slides on some myth-busting facts about the EU settlement scheme. So it will be a series of questions and answers about common misconceptions about the scheme, and it will cover the application process, late applications to the scheme, EU settlement scheme family permits for family members who are living outside of the UK. To the host for tonight's event, Micha, I think I still don't have screen sharing capabilities yet.
Just give me a second, please.
Thank you very much. I have it now.
You're welcome.
So hopefully everyone can see the slides. Do give me a shout if they're not viewed properly. So let's get to the first question. The first question we received from a lot of people is this: status, does that mean my children are automatically protected? Now, we get this a lot from parents who have received their settled status. And for any pre-existing children, so there's children who are born to parents before they receive settled status, and also before the 30th of June, are not automatically protected if the parent applies. Children also need to make their own individual applications to the EU settlement scheme in order to be protected. Every individual person needs to make an individual application. If either one of the parents has settled status, then the child will get settled status. They'll receive the best status that either one of the parents holds. It doesn't matter how long the child has been living in the UK, they will receive the best status if one of the parents has settled status. The law is going to change slightly because this government has draft legislation in place that will allow children born in the UK from the 1st of July to receive settled status if their parents subsequently receive settled status. So if the birth comes before settled status, the children will be automatically British at the point that the parent becomes settled in the UK. This is currently draft law, but when it comes into place from the 1st of July, if a child is born, then the parent subsequently receives settled status, the child becomes British at the point that that parent receives settled status. This is a unique change in British nationality law, and it's been put in place to help children achieve protections much easier. The next question we receive a lot is this: I have pre-settled status. Will I receive settled status automatically after living here for 5 years? Now, the EU settlement scheme doesn't work in this automatic process. If someone has pre-settled status, in order to acquire settled status later, they will need to make a new application to the EU settlement scheme once they've lived in the UK continuously for 5 years and before their pre-settled status expires. This means making a second application to the scheme in a similar way as before, but proving 5 years residence in the UK. I say it doesn't currently automatically change to settled status It's because this process of a two-stage application process, pre-settled to settled status, is slightly contentious, and there's discussions going on politically about whether a second application should be made in order to acquire settled status. However, until those discussions result in any change in procedure, anyone who currently has pre-settled status will need to make a second application to the scheme to acquire settled status later. It won't happen automatically. The next question is, do I have to stay in the UK while I wait for an outcome to my EU settlement scheme? Short answer is no. Once you've made an application to the EU settlement scheme, you are free to travel. The EU settlement scheme is different to other types of UK immigration applications where you are required to remain in the UK until you get your outcome. So you can't with the EU settlement scheme, you can apply and then travel if you need to travel. However, those with pre-settled status or who are applying for pre-settled status must ensure that if they do travel, they don't break their continuous residence ties in the UK, because for pre-settled status holders, they must be continuously resident in the UK for a 5-year period to be eligible for settled status later. This continuous residence rule is quite complex. It does touch on in other questions, so I will come back to the continuous residence rule and absences in another slide. I have been living in the UK for a very long time. Does that mean I'm protected? Now, we receive this question a lot from people who have lived in the UK for decades, 30 to 40 years, and they feel like they're in essence British, although they don't have any paperwork to show that. And this question arises because people who have lived in the UK for a very long period of time believe that that long residence automatically protects them, and it doesn't. Unless a person already holds another alternative UK immigration status. So this means a person has indefinite leave to remain, indefinite leave to enter, any other forms of indefinite or permanent residence in UK immigration law, then they will, if they don't hold anything like that, they will need to apply to the EU settlement scheme in order to protect that long residence in the UK. So if you haven't yet applied to the EU settlement scheme, please make sure you do so before the 30th of June 2021 deadline. The next question is this, my passport has expired. Does that mean I can't apply until I receive a new one? No, it doesn't. You can apply using expired ID documents. It's particularly important now to do so because we don't have much time between now and the 30th of June deadline to get new ID documents. There's just simply not enough time to do that. So if you have an expired document, don't wait until you receive a new passport or a new national ID card before you apply to the EU settlement scheme. You can apply relying on an expired document. You will need to download an application form from the Home Office website using the link that's found here, or Google apply to the EU settlement scheme by post or by email. The reason why you need to download this application form is because the online form that's available for everyone else with valid passports and national ID cards is incompatible with expired ID documents. It simply won't work. So you will need to download this application form from the Home Office website, complete it, and email it to the Home Office before the 30th of June 2021 deadline. If you have evidence, you can attach this evidence to the email that you send to the Home Office, so long as the file sizes are small enough to do so. If you've got too much evidence to email, the Home Office will expect to receive your application form by email, and then you can post your evidence to the Home Office at the address found on this application form. The most important thing to do is, in this scenario, if you have an expired ID document, is to download this form, complete it, and email it to the Home Office on the email address found on the form before the 30th of June 2021 deadline. The next question is, does my current employer have to see my EU settlement scheme status? Now, for existing employees of companies and businesses and institutions, Employers don't need to see the EU settlement scheme status, that's pre-settled or settled status, after the 30th of June 2021, if they've already checked your right to work in the UK previously. This means if they already have checked your passport and seen that you're European and you could be employed and have kept a record of that passport on their files, then they don't need to see your EU settlement scheme status. They don't need to recheck your right to be employed. However, employers can recheck your status, but only if it's done in a non-discriminatory way. This means they can't just highlight EU citizens to recheck their status from July. If they're checking one person's status, then they'll have to check all their employees' status or have another reason that's non-discriminatory, that's not focused on you or EU citizens in general. If they do need to check your status, you can do that by sharing your digital status with your employee. You can log into your status, then create a share code for them to access it. If you haven't yet received your status, but you've applied before the 30th of June 2021 deadline, you can show them evidence that you've made the application, and evidence that you've made an application is an email with your application number, which is a 12-digit number, to show that you've made the application, or your certificate of application. This will be a letter that would have been emailed to you to confirm you've made an application to the EU settlement scheme and to confirm your rights and entitlements in the UK until your application is decided. That's how you'll be able to prove your right to work with your existing employer if they do check your status and it's done in a non-discriminatory way. The next question. I do not have comprehensive sickness health insurance. Does that mean I will be refused settled status? Now, we have this question a lot because there's a bit of confusion with EU free movement law and the EU settlement scheme. Now, as you know, in EU free movement law, any EU citizen can move within the European Union as long as they're exercising treaty rights, which means they're working, self-employed, they're a person who's self-sufficient with health insurance coverage, or a student with health insurance coverage. So if they're exercising these forms of treaty rights, they can move freely within the EU and reside wherever they choose. However, the EU settlement scheme doesn't work like this. The EU settlement scheme is just concerned about presence in the UK. It's about, were you in the UK for the length of time that you say you were in the UK? The scheme does not care about what you were doing while you were inside the UK. So anyone can get pre-settled and settled status based on their residence. It doesn't matter if they're not in employment. It doesn't matter if they're running a business. It doesn't matter if they're receiving benefits. It doesn't matter if they don't have health insurance coverage. The key requirements is proving identity, proving the length of residence in the UK, and not having any kind of conduct or criminal issues that might mean the application should be refused. The next question is, I have not received my settled status yet. Does that mean I am not protected after the 30th of June 2021 deadline? Now, anyone who applies before the 30th of June 2021 deadline has their residence and their rights protected. The key date is the date of application, not the date of when a person receives their status. So if you apply tomorrow, it's unlikely, but it's possible, it's unlikely that you'll get your pre-settled or settled status before the 30th of June deadline. In this case, don't worry, because you've made your application before the deadline, therefore your rights and entitlements are protected until such time the application process says otherwise. So during this period, as I've touched on in the previous slide, you can use your certificate of application to prove your protected rights until you receive your pre-settled or settled status. As I move to the next slide, I would just like to say, if you have any questions while I'm going through these slides, please put them into the chat box as we're going along, and we'll pick them up at the end of the presentation. So please feel free to ask the questions as they come into your head. The next question, and this is where we touch on continuous residence and absences in a bit more detail, is this. I have been outside of the UK for over 6 months. Does that mean I am no longer able to get settled status? Now, it doesn't mean you're no longer able to get settled status. you might still be eligible for settled status, even though your absence from the UK is 6 months or more. However, if your absence is 6 months or more in any 12-month period, that long absence must be for an important reason in order for the Home Office to agree that you haven't broken your continuous residence ties in the UK. Now, this is only relevant for people who are eligible for or have received pre-settled status. Pre-settled status holders must maintain their continuous residence in the UK to be eligible for settled status later. Now, there is published guidance on the Home Office website, which is linked in here, and you can find it using Google and typing in coronavirus EU settlement scheme guidance. And this guidance accepts that some people have been outside of the UK for more than 6 months. And in fact, some people have been outside of the UK for more than 12 months. And they accept that if you've been outside of the UK for long periods of time, and it's related to the coronavirus, then, and you have evidence of that linkage to the coronavirus, then it will not break your continuous residence in the UK. So for example, if someone's been outside of the UK for 12 months or more, this would normally break their continuous residence. However, if that absence for 12 months or more is because someone was unfortunately hospitalized due to COVID and wasn't well enough to travel back to the UK for a long period of time, then that absence will not break their continuous residence because it was linked to the coronavirus and they have evidence that it was linked to the coronavirus. What you'll need to do is you won't need to disclose anything to the Home Office about this now. You will be talking about this in your settled status application when you make that application in 5 years' time or when you're eligible for settled status. When you apply for settled status, you're going to say on the online form that I have been outside of the UK for 6 months or more in a 12-month period, and it was for an important reason. And then you should scan and upload evidence of that important reason into your settled status application and explain why that absence shouldn't break your residence ties and you should still be eligible for settled status. The final point on this slide, and I appreciate this is a complex topic, so if you have any other questions about this, please type them into the comment section of Zoom. The final point is that the Home Office calculates absences on a rolling basis, which means it's not a calendar year, it's not a fixed 12-month period. The Home Office will look at any 12-month window within your 5 years that you're relying on to see whether you've been absent for 6 months or more. So they can check January to January, June to June, November to November, and so on, to check any period within that 5-year window. And also, it's not just one absence of up to 6 months or more, it's all of your absences combined within that 12-month period. If they all combined add up to more than 6 months, then you must have an important reason why you've gone over 6 months. The next question we receive often is this. I have been outside of the UK for over 12 months and it wasn't really for an important reason, but I have returned to the UK in 2021. Can I reapply for pre-settled status? Now, people wouldn't normally be eligible to apply for pre-settled status if they returned after a long absence in 2021. This does work for some people who previously had pre-settled status and then had a very long absence which broke their residence ties. They were able to apply for pre-settled status again, a second grant of pre-settled status, but only if their return was before the end of last year. Because the 31st of December 2021, sorry, 2020, that should say, not 2021. The 31st of December 2020 is the key cutoff date for starting residence in the UK in order to be eligible for pre-settled or settled status. So anyone who returned before the end of last year could apply for a second grant of pre-settled status in order to protect their eligibility for settled status later. But if someone's currently absent now and returns to the UK, either they have to prove that absence now was for an important reason or linked to COVID, If it wasn't for an important reason or not linked to COVID, they wouldn't be able to get a second grant of pre-settled status. And they would need to speak to a lawyer before they try and apply for settled status, because there's a good chance they may not get settled status. So they'll have to consider other visa options if there are other visa options. So if this affects you, please speak to a lawyer before you apply for settled status later. Next question we receive is, I have settled status and I am outside of the UK. Will I be stopped on the border when re-entering? Now, no one with settled status or pre-settled status will be stopped at the border. This has been a topic that's come up recently in the news because there's been lots of stories about people who have been refused boarding on aeroplanes or stopped at the border and being asked to return back home. Now, UK border controls are allowed and permitted by law to ask questions of anyone entering the UK. What happens with some of these cases where people have been refused entry is because there's been some confusion either by the person or border control about what their lawful status is. So if you ever encounter border control questions and they're asking you about why you're coming to the UK, do you live in the UK, and you know what your status is, then just make it clear to them that you have settled status or pre-settled status. They can easily check this information on the border, and so you will be granted entry into the UK. There will just be an administrative burden of the delay at the border and having to answer these questions. It will also be recommended that you make sure your digital pre-settled or settled status is up to date and contains your valid current ID document that you're using for traveling on. Because if it's linked to your ID document that you're using to travel into the UK, then you should in theory be able to use the e-passport gates and gain entry automatically. Or if you're asked questions on the border, it'll be easier for UK Border Force to check your status in the UK. So make sure your digital status is always up to date, not just with your ID document details, but also with your name changes, with address changes or any other information. The next question is this. My child was born after I received pre-settled status. Does that mean they automatically receive pre-settled status themselves? No, this doesn't mean they automatically receive pre-settled status. As I said on an earlier slide, the law is going to be changed for anyone who acquires settled status, then children who are born from the 1st of July will be able to automatically receive British citizenship, but that's only for parents who receive settled status. For parents who receive pre-settled status, their children will not automatically receive pre-settled status or citizenship or any kind of lawful status. Their children will have to make an application to the EU settlement scheme, and they must make that application before the 30th of June 2021. For children born in the UK in the future, well, their status is a little bit more complex, and it depends on the status of the parents. So if the parents are either dual citizens, so Greek, British, for example, or they have settled status, then the child who's born in the UK may be born automatically British. However, children who are born in the UK to parents who have pre-settled status don't receive an automatic status or citizenship on birth. Those children will have to apply for pre-settled status within 3 months of their birth in order to protect their lawful residence in the UK. And then that's at the point that the parent becomes settled, the parent acquires settled status, then you could reapply for your child for settled status at that point. Or your child, if your child was born after the 1st of July, they will automatically receive British citizenship at the point that the parent applies for settled status. Now the next question is, I have missed the deadline. Will my employer dismiss me from my job, and will my landlord take away my flat? Now this is an important question to ask, because those who miss immigration deadlines and who have no lawful immigration status to be in the UK will normally face the hostile immigration environment. And the UK hostile immigration environment intends to make a person's life difficult in the UK in order for them to either sort out their immigration situation or be forced to leave the UK. However, what the government has only just done in the last few days is to implement some type of transitional measures to try and protect people who have missed the deadline, but who are already in jobs or already have tenancy agreements before the 30th of June 2020. So if someone is in employment now and then misses the June deadline, they would be able to remain in employment, and the employer will have a statutory defence to keeping them in employment. However, the employer will need to tell them to apply to the EU settlement scheme, and the employer will expect that employee to have applied to the EU settlement scheme within 28 days. And if the person applies to the EU settlement scheme within 28 days, the employer can continue employing them as long as they continue checking with the Home Office that the application remains outstanding or they've received a status under the scheme. If the employee doesn't apply to the EU settlement scheme within 28 days, then the employer will have to dismiss them from their job. Similar transitional protections are in place for landlords and those who have pre-existing tenancy agreements before the 30th of June deadline. However, these are short-term measures, and all of this must be done before the end of this year. If an employer discovers that someone doesn't have a status in 2022, then on the current wording of the guidance, the employer will have to dismiss them at that point. And what about healthcare? So what about accessing healthcare if I missed the deadline to the EU settlement scheme? Well, anyone, regardless of their lawful resident status in the UK, is able to receive primary care services and register with a GP if the GP is cooperative. However, secondary care, this is long-term non-emergency care, will only be free of charge to a person who's ordinarily resident. This means they have pre-settled or settled status, or they've made a late application to the EU settlement scheme. So if someone misses the deadline, in the window between the 30th of June 2021 deadline and the point at which they make a late application to the scheme, within that window, they will be charged for secondary care by the NHS. At the point from when they make the late application and until they receive a decision on that application, they will be able to access free secondary care, and they will continue to receive free secondary care unless their application is refused. If their application is refused, the NHS can go back in time and then charge them for any access to secondary care during the application process. So accessing healthcare becomes a little bit more complex. However, if someone realizes they need to access secondary care and the NHS will tell them, we're going to charge you for this, then so long as their health permits them to do so, and they can ask their doctor whether they've got time to do so, they can go and make a late application to the scheme, then go back and access secondary care, because then at that point it will be free. So don't pay for it if you've got time to go back and make an application to the scheme. The next question we receive often is this: can I bring my parents into the UK anytime, no questions asked? Now, people can bring their parents into the UK, but there are some conditions attached to this. Anyone can bring their parents into the UK or the parents of their spouse or civil partner, regardless of the parents' nationalities. However, but the parents need to be dependent on the EU citizen or the spouse or civil partner on the EU citizen in order to have the right to join them in the UK and live here permanently. To be dependent depends on the family's individual circumstances. So that in general, this means that the parents are either financially or otherwise dependent on the EU citizen or the spouse or the civil partner of the EU citizen, and they rely on that dependency in whole or in part for their essential living needs. If that's happening, for example, you're sending some money to your parents and take away that money, they won't be able to survive without it. If that's the case, then they're dependent and they can enter the UK via the EU settlement scheme. You will need to have evidence of that dependency at the point that your parents are applying to join you in the UK. Now, the next question is on a similar and related topic. My family members are living outside of the UK and they're European. Can they enter the UK visa-free and apply for an EU settlement scheme status after arriving? Now, this is an important question and an important answer to remember. EU citizens can enter the UK visa-free as visitors only. So this means there are no border controls for visiting, and there's no requirements to apply for a visitor visa before an EU citizen travels into the UK. However, visitors under the UK immigration system have very limited rights and entitlements, and they do not include applying to the EU settlement scheme or any other type of UK visa while inside the UK as a visitor. So if any of your family members enter as a visitor and then decides they want to live here, they can't do so while they're as a visitor. They'll have to leave the UK, and then when they leave the UK, they apply for an EU settlement scheme family permit from outside of the UK before they travel into the UK. If they use an EU settlement scheme family permit, then once they enter the UK, they will have 3 months to apply for pre-settled or settled status from within the UK. In some circumstances, family members will be able to apply for pre-settled or settled status from outside of the UK instead of applying for a family permit. The key point is that any family members that want to come and live with you in the UK, they need to apply to the EU settlement scheme from where they are, and then they can come and live here. The next question is about the deadline. So if I miss the deadline, will I ever be able to get pre-settled or settled status? Now, anyone who misses the deadline can apply for pre-settled or settled status. It's just that they've missed the deadline. What they'll need to do is they'll need to make a late application to the EU settlement scheme if they missed the 30th of June 2021 deadline. A late application means that they're going to have to explain why they've missed the 30th of June deadline, and they will have to have good reasons for doing so. And in some cases, you will need to have evidence of those good reasons. So for example, if someone's hospitalized now and they're unable to make an application while they're hospitalized and they missed the deadline, they can apply late to the EU settlement scheme. Their explanation will be the hospitalization and the illness, and their evidence will be medical records. And then at which point the Home Office should accept that as good reasons for missing the deadline, and then they'll go on to process the pre-settled or settled status application. If you're someone who didn't know you needed to apply and you've encountered the Home Office in some way through your life, the Home Office won't enforce any immigration proceedings against you. They will give you instead a letter which provides you 28 days to apply to the scheme. If you receive this letter from the Home Office, you must make sure you apply to the EU settlement scheme within that 28-day window, because if you miss that 28-day window, it's almost likely that you won't have any good reasons for missing the deadline. And if you don't have good reasons for missing the deadline, then your application will not be processed by the Home Office, and they will just simply send it back to you and say you're not eligible to apply because your good reasons weren't good enough.
Mr. Christopher Desira,
Sure.
Given the limited time, obviously, thank you so much for this presentation. I think this is indeed very helpful and insightful. Cautious of time, and because we have a large number of questions,
Sure.
and I know there are a number of issues and a lot of Q&A slides, and I know that this presentation and for everyone's benefit will become available, but it's good to address some of the questions raised by our attendees.
Yes.
Now, before we move to the Q&A session to be addressed, we noticed some minor voice issues with the message shared by the Greek Embassy. We will make sure that it will become available to our Hellenic Bankers Association UK page straight after this information session. So don't worry about this. Now, before we move to the Q&A, I would like to briefly give the floor to Mr. Theodoros Gotsis if he wants to make any follow-up points to share on this topic, and then we can go ahead. Mr. Theodoros Gotsis, you have the floor if you want to make any follow-up comments.
I would like just to comment that all the slides were very helpful, I'm sure, for the participants, because they are focused on specific issues that might arise and questions that have to have a link with many and different cases, with many aspects. I would like, before going to Q&A, just to follow up on the last slide. Okay, we know that one has to be in a position to explain exactly why his or her application was submitted late, but what happens with elderly people? So people that do not have employment and for one reason or the other might not have been able to submit an application on time. Thank you.
So with elderly people, the Home Office accepts that elderly people will generally have good reasons for applying late, because they'll have a number of hurdles to overcome in some cases. For example, the technological barrier, maybe they have health issues, maybe they're residing in care facilities, or maybe they have no friends or family around to be able to help them make an application. So generally, the Home Office has said they're going to be very lenient on elderly people, and they won't necessarily ask for evidence of their good reason. But so long as the person explains why they've missed the deadline, then the Home Office have said they're going to be flexible and accept the application on face value.
Thank you both. We know that some of the key questions and issues have been discussed, but we still have received a large number of questions. So thank you so much for your enthusiasm and interest in this topic. So let's try to start addressing some of them. So first question would be, would it be possible to extend pre-settled status after the deadline in order to get 5 years of residency?
So there is going to be very limited circumstances in order to be able to extend pre-settled status. And it's mainly linked to the coronavirus and absences. So for example, if someone has pre-settled status and they're locked outside of the UK and they've been outside of the UK for a year and a half, the Home Office have said that for any absence over 12 months, that period beyond 12 months will not be counted within the 5-year period. So in which case someone's pre-settled status will expire before they even have 5 years to rely on. So in these circumstances, the Home Office will allow a second application for pre-settled status to extend their pre-settled status to get them to that 5-year window. But it's only going to be based on long absences and very long absences linked to the coronavirus. Any other circumstance, you won't be able to reapply to extend pre-settled status. You either have to reach settled status and be eligible for it, or if you're not going to be eligible for settled status, you need to speak to a lawyer to consider what other visa options you have available to you.
Maybe, thank you, Mr. Desira. A relevant question, because you related to this one, and also relate to the point you made about the pre-settled status is, if somebody, it's one of the questions we received, has received actually the pre-settled status until, let's say, 2024, and they apply after the 30th of June this year, is there a difference, and will they have a problem doing so afterwards?
So if someone has pre-settled status already and they apply after the 30th of June?
My understanding is, let's say they get the pre-settled statement after the 30th of June. Okay. So they haven't got, they don't have it yet, but that's before, I guess, the 2024. So then, is there any issue with that, any implications, anything they need to know?
So thank you for explaining. I understand now. So there's not any implications, and in fact you don't have to wait until you get pre-settled status, and you don't have to wait the whole 5 years of pre-settled status to apply for settled status. You're eligible to apply for settled status at the point that you've acquired 5 years continuous residence. You don't need to have held pre-settled status during that whole period. So for example, if someone's been living in the UK since 2018, and then they received pre-settled status this year, then they're going to be eligible for settled status in 2023, not at the end of their pre-settled status, because between 2018 and 2023, they've acquired 5 years continuous residence in the UK, and only 3 of it was with pre-settled status. But that doesn't matter, because it's just about proving you're continuously resident in the UK. So you can apply for pre-settled status as soon as you've lived in the UK for 5 years. You don't have to wait until your pre-settled status is due to expire before you apply for settled status. You can apply at the points that you've been here for 5 years, and you have evidence of being here for 5 years.
No, that's clear. Maybe another one is, let's say someone who has received settled status and they want to apply for the British passport, assuming they travel at any time within the next 12 months before the actual application, does this absence breaks that continuous time that they were resident here? And is there any other requirement for the application for British passport compared to what it was, I guess, before Brexit?
Yeah, so there are different residence rules for citizenship, and they're different to the EU settlement scheme. So once someone gets settled status, they can keep their settled status, and it will only lose settled status if they've been outside of the UK for 5 years or more. When they come to the point where they want to apply for British citizenship, they're ready for citizenship. Well, there's different residence rules. So for someone who's not married to a British citizen, or in a civil partnership with a British citizen, they will need to have been resident in the UK for at least 480 days within the 5 years predating the application. And also they must have been, they must not have been absent for more than 480 days within the 5 years predating the date of the citizenship application. And they must not have been absent from the UK for more than 90 days in the 12 months preceding the date of the citizenship application. So even though you might meet the residence rules and get settled status, your absences might make you ineligible for citizenship. The Home Office has discretion to waive longer absences when you're applying for citizenship, but the reasons for those long absences are different to the reasons under the EU settlement scheme. So if you want to become British and you know you've been absent for a very long period of time within the 5 years before you apply for citizenship, and within the 12 months before you apply for citizenship, speak to a lawyer so they can understand how many days absent you've been within those 2 periods. And the lawyer will also be able to explain to you whether your reasons for that absence will be acceptable by the Home Office. And if it's not acceptable by the Home Office, then what you'll need to do is you'll just need to simply wait and delay your citizenship application until you've been inside the UK for within the permitted period before you apply for citizenship later.
Another question is from a younger member of the audience that will come and study here in the UK. The question is, are there any available concrete details, I guess, any information that they can find out with regards to students who come after the 30th of June? I assume that might be September. And they wish to remain in the UK post their studies for work or otherwise.
Yeah, so anyone that's coming to the UK now for the first time and coming here to study, they'll need to enter the UK with a student visa. So that means they need to have been accepted on a course within an educational establishment sponsored by the Home Office. They need to demonstrate that they can afford those course fees and they can afford to maintain themselves while they're in the UK. There are going to be rule changes in the immigration system, which will enable students to stay here beyond their studies in order to access employment much easier than they could now. Now, it's going to be called something like a post-study work visa. But currently the rules are you're either a student or as soon as you're ready to leave studies, you can access a skilled job and apply for a skilled work visa. Obviously, students are not often able to obtain skilled work visas because they're only just starting in their career. So the government is yet to introduce this post-study work visa, but they intend to introduce it at some point soon in the future. Interestingly, these post-study work visas used to exist before, but previous governments cancelled them because they thought too many students are staying in the UK after their studies. Now, because of Brexit, they need students to stay in the UK after their studies, which is why they're going to introduce this post-study work visa. The post-study work visa will mean you can access most employment. It doesn't necessarily need to be skilled or meet any kind of salary thresholds, and that you will need to work at an employer that's sponsored by the Home Office to employ foreign workers, so to speak.
This is a very interesting development if it happens. What about the reason why they might need to leave the UK for, let's say, 6 months to 12 months? Many students or young professionals, they need to join a compulsory national army duty. Could that be a legitimate, let's say, important reason for them to be away from the UK for that period of time? In Greece is around a year, and then come back. Are there any exceptions to the rules?
That's one question I can't answer tonight because we haven't seen what these new rules are going to be like. Previously, the old rules used to allow post-study students to apply for post-study work visas either in the UK or later on within a certain window of time. Maybe these new rules will allow the same thing. So if you were a student at some point in the last 3 years, you're still eligible for a post-study work visa. So in this scenario, the person can go back home, complete the compulsory military service, and then apply for that post-study work visa from where they are. However, we don't know. I mean, we just know this is a commitment to reintroduce this type of visa. We haven't seen the draft legislation yet. So we're not sure how it's going to work in practice yet. So this is one to watch out for later.
That's clear. Then what if, let's say, one of our friends here asks if they have received the British citizenship, but you have held the citizenship ceremony, so they're officially British, but they don't have a British passport yet, because I think that takes around a month or two, if I remember from my experience. Can they use that certificate at the airport as a proof that they are indeed a UK citizen, or should there be any issues and they need to wait for the official passport to be delivered?
So they can rely on the certificate of naturalization, and it's because the certificate of naturalization is proof of British citizenship. Even though the passport is used to prove citizenship, the passport is in essence just a travel document, and the real evidence that someone is British is that certificate. So they can rely on that certificate if they have problems at the border. However, they shouldn't, because even if they've become British, the records of settled status will not be deleted. So they should still be able to gain entry in the UK relying on their digital settled status, even though they've subsequently become British. But if they want to, they can use the certificate of naturalization at the border to prove that they have a lawful rights to enter the UK.
And what about the settled status? So how do you prove your settled status at the UK border? Will it be just a paper, like a letter from HO, or will it be some sort of a boarding card that somebody can have with them? What is the case there?
Yeah, so EU citizens won't have any physical evidence of their settled status, so it's still going to be tied to the digital settled status. However, what the UK Home Office are doing is that they're digitalizing the borders. So what will happen is, so long as your current passport or national ID card that you're using for travel is tied to your digital status, so it's updated with your current travel document, when you reach the e-gates and you scan your passport to gain entry, the e-gate should automatically check and verify that that person has settled status and then open. If it doesn't open, maybe there's a technical glitch, then you'll have to use manual border controls, at which point the border agents at the border controls will also be able to check your digital status by scanning the chip in your passport or national ID card if they're biometric.
We have another student that is asking, so they currently study in the UK. Since the start of the COVID-19 pandemic, and obviously they were forced in a way, or most of them decided to return back to their countries. In this case, it is Cyprus. There were a number of flight cancellations, And also, as everyone knows, there were many online classes, especially last year. So that person, that student was away from the UK for more than 14 months. Will they be able to apply for a settled status later on? Does this time frame count or not? And also, Mr. Desira, I know we have a few more questions. I don't know if we can extend it for 10 more minutes to address some of them. Okay, that's fine.
Yes, I'm happy to stay as long as required. So for students who are studying remotely and they've been outside of the UK for more than 12 months, the Home Office absence guidance under the EU settlement scheme, which we've linked on the slide, will be the answer to this question. And what they say is if you've been outside of the UK for more than 12 months, then you won't have broken your continuous residence ties. However, if it's longer than 12 months, you need to have a very good reason. And what they say is that if you were advised by your university not to return to the UK and continue studying from your home country due to the coronavirus, then the Home Office will accept that long absence of 14 months as not disrupting your continuous residence ties. However, in your case, to be able to ensure that you get settled status later and be able to rely on this important reason, you will probably need to make sure you get some kind of evidence, if it's a letter or an email from your university, to say that they advised you not to return and to continue studying remotely because of the virus. Because I'm sure the Home Office will expect to see evidence of that. And and the guidance actually stresses the point advised by your university. And in fact, it also includes employers in this extent. So if they're saying advised by your university or your employer not to return to the UK and continue studying or working remotely from your home country due to the virus, then it means that what the Home Office is saying is they accept that it was out of your control. The decision making was done by the university or your employer, and therefore they'll accept the long absence. And in this case, I think the Home Office will need to see some form of written evidence from your university or your employer, if the circumstances relate to employment, to prove that you were advised to stay where you are and continue these activities remotely. This touches on the extension of pre-settled status topic. So because you've been outside for 14 months, the 4 months beyond that 12 months of your absence will not count towards your 5-year period in the UK. So if your pre-settled status expires before you've got 5 years residence in the UK, you will need and be expected to apply for an extension of your pre-settled status so you can get up to that 5-year period. Any absence beyond 12 months is not counted for your 5-year period for settled status.
Thank you so much. Another question is, if I have received the pre-settled status and looking to apply for settled status, having covered the 5 years period in the UK, does the 30th of June this year deadline matter, or it is as it was in the past?
No, it doesn't matter at all. So the 30th of June 2020 deadline, 2021 deadline is about the first application to the EU settlement scheme. So once you've made one application into the scheme, you have no deadline, you have no fixed deadline to apply for settled status later. If you just as long as you made your pre-settled status application before the 30th of June 2021 deadline, then you don't have to worry about the 30th of June deadline for settled status. You then must apply for settled status once you've got that 5 years residence in the UK, and certainly before your pre-settled status expires. If you apply after your pre-settled status expires, you will be making a late application and your rights and entitlements in the UK may be interrupted. So the ultimate deadline to apply for settled status is the expiration date of your pre-settled status. Please apply before your pre-settled status expires.
That's clear. We have another interesting question. What happens with the EHIC card? I think that stands for the European Health Insurance Card. Will this remain valid, or there's now what we have, is it relevant, the UK Global Health Insurance Card?
I mean, that I'm not sure about, so I'll have to check that and come back to you. That's not within my remit, I'm afraid.
Well, fair point. Another question was, that's a long one. I tried to I know you have sent us a lot of questions, so I try to cover as many as possible. So thank you for your patience on this. One of our attendees mentions that they got the settled status in October 2019. They have been living in the UK since September 2013, but they were studying masters and PhD most of the time, and only worked for about 2 years throughout this period, and they have never had a comprehensive sickness insurance. Does that mean they cannot apply for permanent residency card, which could lead to a citizenship? Do they still need to wait for the 5 years period? Does any of that previous period that they were here count? And can they apply for that in the future?
Okay, so we're mixing up a few topics within this question. So permanent residence cards, you can no longer apply for permanent residence cards. That process is ending. But you've got settled status, so you don't need a permanent residence card. Settled status is the route into citizenship. So as long as you've had settled status for 12 months, or you're married or in a civil partnership with someone who's British, at which point you don't have to wait 12 months. As long as you've had settled status for 12 months, then you're eligible, you meet one of the eligibility requirements for citizenship. When it comes to citizenship, another requirement is being a person of good character over the 10 years or however long you've been in the UK. If it's shorter than 10 years, that predates your citizenship application. Good character includes a number of things, as well as criminality. It's about lawful immigration status in the UK. So if you're an EU citizen and you weren't technically exercising your treaty rights in the UK because you didn't have comprehensive sickness health insurance coverage before you got settled status, then you will technically not meet the good character requirement. However, the Home Office have said that for citizenship applications, they will ignore the health insurance requirements so long as a person, when they're applying for citizenship, they meet all of the other requirements. And the reason is that many people didn't realize the need for comprehensive sickness health insurance coverage to live lawfully in the UK if they're a student or a self-sufficient person. So the majority of people don't have health insurance. So this is why for citizenship, they'll be more lenient, but you need to make sure you meet all of the requirements of citizenship and also explain why you didn't have health insurance. The explanation will normally be, I didn't know I needed to have it. If you're not sure, citizenship is a fairly complex process. If you're not sure, speak to a lawyer before you apply to make sure you're eligible for it. One key point is if you do apply and you're refused, the punishment is financial. You'll lose all of the money you've paid to the Home Office, but your settled status is still secure. Being refused citizenship doesn't affect your settled status. You will still have settled status.
This is very useful. I think that the whole information session has been extremely useful for the people who have attended this, and obviously it will become available. I would like to thank you, Mr. Christopher Desira, for your presentation and all your Q&A session. I would like also to thank Mr. Theodoros Gotsis for your time and insight on behalf of the High Commission of Cyprus, as well as Ms. Pinelopi Micha, her message I think now is available on our page with regards to the mission of the Embassy of Greece. Last but not least, I would like to give the floor to Mr. Louisou, the chairman of the Hellenic Bankers Association UK, for the closing remarks. Thank you, everyone, on my side. Mr. Louisou, you have the floor.
Thank you, Greg. Christopher, thank you very much for attending this, this event and for answering all these questions. I'm sure if we have some additional questions, perhaps we can reach out to you and you can share some insights. I would also like to thank the Consul General, Theodoros Gotsis, for his presence today, and also Mrs. Pinelopi Micha for also her presence. Apologies about the message that it wasn't really audible earlier. What Mrs. Micha said actually is that the Greek embassy is always available to help. And we know that both the Greek embassy and the Cyprus High Commission are doing an excellent job. There have been so many cases in the past that some of them they've been in the news, and there've been publicity about them and how they've been handled by the Greek embassy, how well they have been handled also by the Cyprus High Commission. From our side as Hellenic Bankers Association, I would like to note that we're close the Hellenic community, both the Greek and the Cypriot communities. We treat them alike, and we'd like to assure that anything we can help to assist the community will be available and at hand in doing so. Lastly, I would also like to thank, of course, Greg for his coordination this evening, and also Michael Dimopoulos for helping with the event as the head of the events committee at the Hellenic Bankers Association, and also Christina Nusia from the external committee of the HBA for all the communication with the embassies of the UK and the Cyprus High Commission. Thank you all, and I wish you a pleasant evening, and thank you for being with us tonight.